Good morning, and thank you, Senator Harkin, for inviting me here today, and Senator Leahy for inviting me to the judiciary hearing tomorrow. I'd also like to publicly thank my two attorneys, Beth Townsend and Mike Carroll. They've been working tirelessly on my behalf for 7 years because they believed in me, they believed in the facts of my case, and now the greater cause that brings us all together here today. I'm very honored to participate in this process, but I certainly never imagined that my case would end up here when it started 7 years ago. That's when my employer, Farm Bureau Insurance, or FBL, merged with the Kansas Farm Bureau, and apparently not wanting to add any more older workers, they offered all of the people in the Kansas Claims Department who were over 50 a buyout to eliminate them. And at the same time, everyone who was over 50 in the Iowa operation and was a supervisor or above got demoted, all at the same time. I was age 54 at the time, so I was included in that sweep, even though I'd had 13 consecutive years of performance reviews in the top 5% of the company, and had dedicated most of my working life to making Farm Bureau a better company. My contributions were very well documented, and they included the development of a new package policy upon which Farm Bureau was going to be relying for their future growth. My position was then given to a much younger and newer employee with far less experience and education. Since age was the obvious reason, I filed a complaint, and 2 years later, a federal jury spent a week listening to all the testimony, seeing all the evidence, and being instructed on the ADEA. They were even admonished to rule against me and in favor of FBL if they could find any reason other than age for Farm Bureau's actions. The verdict still came back in my favor, and I thought the ordeal was over. That was in 2005. That's when the thing started getting lawyered to death, eventually ending up at the Supreme Court this year over one single issue in the jury instruction. However, instead of addressing that one issue, the court broke its own protocol and procedure to hijack my case and use it as a vehicle to water down a law that was written by the branch of government closest to the people. We came here in March believing in the rule of law and its consistent application to all areas of discrimination. We were disappointed and disillusioned. We believe that this issue transcends partisan politics and presents an opportunity for both parties to come together and protect their aging constituents back home. On a personal level, this has been a long, rough ride, but what's becoming even harder is watching the collateral damage that's being inflicted by the court's ruling. Because of their decision, my legacy to work in America will be having my name associated with the pain and injustice inflicted on older workers, because it will be nearly impossible to provide the level of proof now ascribed to this one type of employment discrimination. That's a heavy burden to place on one guy who simply sought to right one act of age discrimination. I wasn't the one who changed the law. 5 activist judges did. I can only urge Congress to step up again, like they did in the Ledbetter case, and restore the ADEA to its original intent. And again, I'd like to thank the senators and Representative Miller in the House for the leadership role they're taking on that behalf. Thank you very much.